We have the thumbs up, and it is 7 o'clock, so I will call the Wednesday, September 17th, 2025 meeting of the Whitley County Planning Commission to order. The first item is the Pledge of Allegiance, so I will ask if everyone wants to stand and face the flag, please.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
May we have a roll call vote, please, Brent?
Yep. Travis Baker.
Here.
Chad Banks. Dane Drew.
Here.
Brent Emmerich.
Here.
Jack Green.
Here.
Thor Hodges.
Here.
Mark Johnson.
Here.
Kim Stetzel. Joe Wolf.
Here.
John Woodmansey.
Thank you. Next item is the previous meeting's minutes, but as lengthy as those are not finished yet, so we'll skip over that item on the agenda and move to the oath to witnesses. It looks like there's just one witness tonight, so if you would stand, we will have our legal counsel give you that oath.
Do you swear or affirm that any statements you make before the commission tonight will be the truth? If so, state I do.
I do. Thank you. See no old business, we'll move right into new business, and my understanding is we're going to combine items 1 and 2 and discuss both of these simultaneously. So first item, 25W Vacation 4, Dwight and Patricia Stetzel, and 25W Subdivision 14, also Dwight and Patricia Stetzel. So I will ask Nathan if you have a staff report for us, please.
Nathan, real quick, Mr. President, I need to recuse myself for personal interest in both of these.
Okay, thank you.
Thank you. So going to the slides here for everybody. So 25W Vacation 4 is a vacation of Lot 1, the only lot in Stetzel Grainery Subdivision, located on 200 East, half mile north of 900 South, south of Log, zoned AG agricultural. This was recorded back in 2024. It was necessary because of the transaction going on, created a new lot, which triggered the need for platting. Further transactions are proposed now, and the petitioner can give more detail on all the different steps that are involved. But one of them is to vacate lot number 1 of the Grainery subdivision, recombine it with the adjacent unplatted property, plat a new lot as part of it, and then rearrange ownerships overall. You can see there in the table that with the vacation, the minimum acreages, sizes, and so on are still met. So all of the zoning parts are still compliant. Highlighted in blue in the center is lot 1 of the Stetzel Grainery subdivision. As I mentioned, Log is to the north. Closer view. This is the plat of the Grainery subdivision that would be vacated. The plat vacation criteria. So giving some notes on that. Generally speaking, because of the desired change in ownership, the reason that we did the original plat is now changed as well. So there definitely is conditions that have changed. I would say that it's neither particularly in the public's interest, nor is it not in the public's interest to vacate it. And when we've had that situation before, we typically say, yes, it is in the interest because whatever the petitioner is doing has meaningful impact. So we go along with them. And then number 3, diminishment of value because the entire property is owned by one person. They know what they're getting themselves into. So if there is any change in value, that's because of whatever they're doing. So that's kind of a moot point. Do have 2 proposed conditions to attach to the vacation. One is that the remainder acreage has to be combined in order to meet the zoning code criteria. And number 2 is that the previously dedicated right-of-way is not also vacated, that the dedication still stands. Going on to the subdivision component of this. So basically, we're vacating a one-lot plat and creating a one-lot plat. Slightly different arrangement, basically next door to the current one that's being vacated. Similar to the previous one, platting is still required. This is still the first lot from the 2018 parcel, so no rezoning is required, and you can see again with the plat that the minimum criteria are still met. Again, the reference aerials here, and then you can, if you remember what the Grainery subdivision looked like, it was primarily located around the grain bins and down here, and that now is vacated and would be combined with, or could be vacated, would be combined with the field to the west. This then is the proposed new plat on Barnes to the north. Overlaying the proposed on top of the current situation, and again outlined in blue, is the current to be vacated plat, and then what is proposed is up here. There is that little gap there between them that winds up being combined, so that's kind of a unique piece. Generally, comments were very minimal on this. This is, again, primarily due to ownership and not really for new development. So the proposed conditions, number one, that the Grainery subdivision needs to be vacated, that the remainder acreage be combined. Number 2 and 3 are standard conditions that we typically see. So with that, any questions for me?
I don't hear any. Thank you, Nathan.
Thank you.
At this time, I would ask the representative for the petitioner to come to the podium and speak about this project.
My name is Ryan Pepler. I'm with Walker & Associates at 112 West Van Buren Street in Columbia City. So this, the first part of this, the vacation of the Grainery subdivision, is part of a larger plan to reconfigure the tract lines out there on the Stetzel's site. Part of if the vacation is granted, part of that land will go to the Stetzel's house, which lies south of there, and part of the other part of the subdivision to be vacated would be part of a larger farm piece, somewhere in the neighborhood of about 45 acres that would be attached to the west. The new subdivision to the north is the Stetzels would like to hang on to the large barn and shed. It's where Mr. Stetzel's shop is located, and they have plans to hang on to that for now. And so in order to split that off separately, I had to go through the subdivision process. So that's what we're asking for on this one. So this is part of, like I said, a large plan. I've got 7 or 8 different surveys configuring this, all following the rules laid out in the zoning ordinance. So.
Thank you. Planning Commission, do you have any questions? Thank you.
Thanks.
Planning Commission, the floor is yours for comments, questions, motions.
Mr. President, we still need to have a public hearing.
Sorry. Yeah,
officially.
We do need to have a public hearing, even though no one is here. So the podium is now open to anyone in the public that can speak for or against this petition, both of these petitions, number 1 and number 2. I will close public comment and now turn it back over to the Planning Commission.
I'll move for a favorable recommendation for 25W Vacation 4 and 25W Subdivision 14.
Second.
With the
With
conditions?
Conditions of staff.
Thank you.
Yes.
I'll second that with the conditions.
Any further discussion?
Is the vacation a favorable approval item, or is it an item that we approve? In the subdivision, there would be a favorable approval. Is there a difference there, Nathan?
Since you're asking, both of them are approve, deny, approve with conditions, or continue. So, same set. Usually when somebody says that, we take it in as they mean approve. But
Approve.
I'm not questioning your verbiage. I'm just questioning whether.
Technicalities of
Yeah.
it.
Legal, making sure we're doing that right.
Yeah.
Yes.
happy to answer the questions.
Understood. Good question. Any other questions? May we have a roll call vote, please, Brent?
Joe Wolf.
Aye.
Kim Stetzel. Mark Johnson.
Aye.
Thor Hodges.
Yes.
Jack Green.
Aye.
Dane Drew.
Aye.
Chad Banks. Travis Baker.
Abstain.
And Brent Emmerich.
Yes. Motion passes unanimously. Moving on to other business, we do have a discussion that Nathan put together a few slides for based on my request, and we're just aiming to answer a few questions. When I have people ask me questions I don't know the answer to, and when I asked some commissioner questions, they did not have the answer either. So we do have training sessions occasionally, but for any of the ones that I've been to, this topic hasn't been discussed. So I thought this would be a good meeting, a short meeting to get some education and hopefully clear some things up and be in a better position to serve the people of Whitley County. So I'll turn that over to you, Nathan.
Thank you. Yes. Brent had emailed me a handful of questions, and I have put a few slides here together, and Liz chimed in with some answers as well. So we'll kind of tag team as I run through these for everybody's sake. But again, I know a few other people have asked me as well a couple of these questions over the years. So kind of a refresher as well as some new information, I think, too. So so the first one is, how is legal counsel selected? So this slide is from the state statutes.
We're okay.
Yeah.
Okay.
Shots.
Yeah.
Not sure if you guys get workers' comp, so. The state statute, IC 3674-311, states that the advisory plan commission, you guys are in your advisory plan commission, may appoint employees as necessary for the discharge of the duties of the commission. So if you wanted to hire people, staff, for example, the state statute says you can. Further, then the commission can contract for any professional counsel. So engineers, legal counsel, and so on, all are covered under that services and professional counsel. However, on the next slide, there's a caveat to that. I also included the area plan commission. Area plan commissions are plan commissions that are combined county and municipal. And it's interesting because they have a separate section here, and they actually are obligated to do hiring. So, for example, Noble County is a area plan commission, if I recall correctly. So they actually have, when they have an opening, the plan commission itself advertises. It's not the county, it's not the municipality, it's the plan commission doing that hiring up there. And so, again, kind of an interesting point. Wanted to leave that in there for. Okay, it's interesting to me. I'm not sure if it's interesting to you guys, but it's in there. The caveat then is, at a local level, we actually have a joint enabling ordinance that created the department, which is currently it's ordinance 911-93, passed back in 1993. There was a previous joint ordinance from 1991 and a previous one to that. But this is the most recent version. In that, it very clearly states what's up on the screen, that the city council is responsible for employment of attorney or attorneys for its plan commission, and the Board of Commissioners is responsible for the employment of an attorney or attorneys to represent the plan commission and BCA. Another section also further says that staff for the joint department is selected by the county commissioner. So basically we're county employees. But again, back to the attorneys, this actually clearly states that the county commissioners are the ones who select it. So I know that was kind of a common question that I have kind of talked around out of precedent more than anything, but this is where that precedent started. So while state statute says that you can, we just don't do it in Whitley County. So then another question was scope of representation of the legal counsel that we have for the Plan Commission. Typically we have legal counsel be the same for Plan Commission and BZA. That's not always the case, but it's typically the case. I'll say with the city, for a while we actually had different attorneys for Plan Commission and BZA, still the same firm, but different attorneys. Anyway, legal counsel represents the Plan Commission as a whole, not necessarily the individual members' interests. And that's, Liz, do you have like a case example maybe to give? Because I'm drawing a blank.
I mean, the best way I can, it's going to be there are going to be situations, of course, that are fact specific. That's why attorney's favorite answer to everything is it depends. But let's say, I mean, I think, Dane, we talked about this the last meeting where you thought someone was posting stuff on a website or saying something.
Yeah, I just didn't ask if somebody would do that.
Yeah, so you asked that hypothetical. So if somebody had actually said something about Dane that was untrue at that minute, and it had cost him, let's say, an employment opportunity or something, if he wanted to pursue some kind of defamation or lawsuit against that person, he would have to go to his own personal attorney. That would not be within the scope of, I know it's related to Plan Commission, but it's not within the scope of Plan Commission. So that would be something that would be the individual member's interest, not the Plan Commission.
What if it's, to touch on that subject a little bit, what if it's harassment that involves stuff we do here?
That's going to depend on the nature of what it is. Like if it's coming to Nathan, addressed to you, or if it's coming to you if it's coming to your home, I'm going to say that's probably a personal report to the sheriff's department or state police and deal with it that way. I mean, I would have no problem telling you to get a protective order or do something like that. But as far as how we handle it officially as a board, or how I advise Nathan or you guys to handle it, it would depend on whether they're doing it to you, like if they're sending threatening material here, addressed to you here, as a Plan Commission member, as opposed to like at your home. Little facts like that might make a difference. But if you're not sure, I would always encourage you to come ask me about it, because the worst thing I'm going to say is I don't think that's something I can do, because I'm going to be very cautious about that, because it's obviously taxpayer funds paid for what I do. But I would not hesitate to connect you with an attorney that I thought would do a really good job, and I'd rather get you connected with somebody that I know is going to do a good job for you than have you kind of wing it and not get good advice.
And an interest that would be the whole interest would be backing up the decision. So if a decision that you've made gets challenged,
Right.
legal counsel represents the commission as a whole, even if it was a split vote. If it was 5-3 or whatever the vote may be, that was still the decision of the council or the commission as a whole. So
we had, I don't remember how long ago it was. I wasn't legal counsel. I think Dawn was. There was an appeal of a Plan Commission decision.
mm-hmm.
There was a petition for judicial review. So Dawn, as the Plan Commission attorney, her job was to defend that decision in court. So if there were ever an appeal, we haven't had one since I've been on. If somebody were to appeal a Plan Commission or commissioners, it would be both. Those decisions, my job would be to represent the Plan Commission and defend your votes in court.
So moving on then to the rest of the slide there. Well, you already mentioned reach out to us with, or to you with legal questions, especially if it's really what do I do sort of situation, like do I have a conflict of interest, for example. So feel free to reach out directly to Liz if you kind of say, hey, this is the situation here. It's my cousin that's involved in this case. Do I have a conflict of interest, or whatever the question may be. If you have questions about legal process, precedent, stuff like that, either Liz or I both, we both do that research. Liz more from a broad legal standpoint, me from more of a topical standpoint, particularly the land use side of stuff, and then ramifications of decisions. So if we go this way, what does that do? If we go this way, what does that do? Those were just a couple examples that I thought of, but again, don't hesitate if it relates to Plan Commission to reach out. Let's see, if it's something that's on the substance of a case, so what do they mean about whatever they're proposing? That's something to direct to me, more about the nature of what's being proposed. Again, Liz is legal counsel. There may be things that overlap, so don't hesitate to ask, though. Worst thing is not asking and not knowing. Always want you to be educated and knowledgeable. And then a general note, if you do ask Liz something, typically she'll discuss it with staff so that we can then relay information. If it's something about your own personal conflict of interest, we can do that. But if it's a broader question, we'll relay it for everybody's information, so everybody understands and has the same basis. So, questions on that component of stuff on the scope? Okay. So another question was, at what time does legal counsel need to recuse themselves? So here are a few slides straight from the Indiana Rules of Professional Conduct, basically copy and pasted. This one is dealing with clients' interests. When you have two different clients, basically you have to recuse yourself from one. Correct me if I'm wrong on any of these. Rule 1.8, basically the same thing, different angle to it, different perspective. 1.9 is recusal if you have former clients and former employers. So if you switch law firms and you have a case dealing with a former client at a former firm, still have to recuse yourself. And then if you switch firm, or excuse me, if there's any other attorneys in the same firm, you all are treated basically as one. So if any of you have an individual conflict, it applies to everybody. So boiling all of that down is basically these 3 points. So attorneys should not represent a client in instances when their ability to advocate on behalf of that client is materially limited by a duty owed to another. The attorney must avoid putting their personal interests ahead of their client's interests. So in this case, if Liz actually has financial interest in a case, she should recuse herself. So very similar to the same rules you guys follow, as well as myself. I have very similar rules, not quite the same, but similar rules from my own code of ethics, being an ASAP. So very similar across the board for personal interests. And then the third point would be using information gained from representation of a former client to the disadvantage of other clients. All of that said, if the conflict of interests can't be resolved, sometimes they can be resolved just by notice to everybody. If they can't, then we need to figure out alternate counsel. So the way we do that Upon the receipt of the agenda, the attorney reviews the petitions, tries to figure out if there are any potential conflicts. Are the people involved clients, basically? Typically, they're pretty rare because we have very few clients that are represented by the same firm who are also petitioners. It does occasionally happen. Especially early on, you had several conflicts early on as clients had, but those clients have started to roll off. So then, let's see. When a conflict of interest does exist, Liz will notify us, hey, you probably should consider seeking alternate counsel. We'll kind of discuss why, kind of give an idea of who else we might be able to contact, maybe another law firm in the city, but it might be a type of conflict that every attorney in the city has because they've dealt with the same person. We've had that, I think one time we've had all the law firms say, no, that person has been a client of ours, so they had to recuse themselves. So wound up going potentially outside the county even. The attorney wouldn't discuss anything more with staff or members of the Plan Commission BZA, at least not substance of the petition. Again, things dealing with legal process that would apply no matter what the petition was, that's still fair game. But the actual substance of the petition is off the table. And then, of course, if there's a conflict, similar, again, to you as members, if you have conflict of interest on one case, you can still participate in the other cases on the docket. I will say that in some cases, or probably about half the time, alternate counsel isn't hired because of cost, the availability, as I mentioned, and typically the ministerial nature of the case. So basically, how likely are we to get challenged if something was to go wrong? So what's our risk versus our cost to get an alternate counsel in? So
like tonight, for example,
yeah.
Probably not high risk if I had a conflict.
Yes. So that's covering those questions. One question was, well, how much do we pay? And that is set through the budget of the department, through the council, and by the commissioners, and then by contract to the law firm. But there on the screen, the most recent bill is on the upper half, just giving you a sense as to what Liz has billed us for. I will say that previous legal counsel billed us for every single meeting, whether we held one or not. That was just the rate structure that was agreed upon. Liz, it is paid hourly, but you'll see there in June, there was no bill for the BZA meeting. The bill was for the Plan Commission meeting, and in July, there was no bill for the Plan Commission meeting. There was a bill for the BZA meeting. In my opinion, she's billing for the time she's actually involved in a case. So if there's a meeting that she's making billable hours from other clients, I guess, I don't know.
Well, much to my
If that's fair to say.
sometimes in evening meetings I forget to put the time in the next morning, so there's a little bit of that going on too. Just don't tell my partners that that's what's happening.
This
I'm a
is
little bit
recorded.
concerned with that third line. Telephone call with Nathan regarding meeting of 8/20/25. There's nothing that you guys should be talking about for 50 minutes. Nathan, you're talking too much. You need to get your point out and move on.
That's only 30 minutes, right?
It's 30 minutes.
Yeah, it was 30 minutes.
Yeah.
That's
0.5 hours.
5 hours.
Half an hour.
30 minutes. That's still too long. You should be on phone for 30 minutes.
I duly noted. I try not
So
to
what's
talk.
the point 3 then? What do you increments do you break it down in 6 minutes?
Yeah.
Every 6 minutes there's a
I
charge.
think that was reviewing emails. That was in preparation for the August meeting, which had a lot of stuff going on with it. That does not, and Nathan can tell you, that is not what a monthly bill typically looks like. Nathan and I rarely I will usually give him, like today I gave him a call when I was driving over to a home visit for a guardian ad litem case I had. And I just said, is there anything on your radar for tonight that you want me to know about? I'm not even I didn't even put time in for it. I just like to check in with him the day of the meeting to check. If it's substantive and it requires me to do something beyond what we talked about, then chances are I'm gonna go for it. It's just it's also a way to let my client know what I'm doing on their behalf. But there's a fair amount of stuff that I don't bill for all those phone calls.
Yeah.
Or sometimes the random emails that shoot. Like, there was probably one day, probably 10 emails going back and forth about remonstrators and stuff that had been filed. I'm not going to bill for all that. It would drive me crazy to try to figure out how to log all that in, but I'll just look at them, review them.
And I will speak from my experience. There are some law firms that know how to bill for every single email that they may not even read, but that touches their inbox. So I'm appreciative of this reasonable approach, in my opinion, at least. And then also of note, you'll note the last line, the last billing line there, meet with Nathan and Craig regarding building violations. That's a zoning and building violation. We actually have an enforcement case that we're handing over to Liz to take up on Blue Lake. So that's what that is a meeting to basically say, this is what we've done so far. We need legal counsel to take it over.
Who approves the expenditures, or who approves this bill before it gets paid by the county?
The commissioners, it goes to their commissioner meetings to approve. So like my public defender, when they get paid from that, it goes to the commissioners to approve that bill before it gets paid to us, that invoice before it gets paid, and then it goes to the commissioners.
So I review it to make sure that the charges are reasonable, and then it gets put into the system.
And then same with the health department. My bill for the health department goes to the commissioners every month, and then it gets paid out.
Does it seem unreasonable that we would be provided with that with our minutes every month just for our information? Is that allowable? Is that information? I mean, obviously it's a public record. It's accessible to anybody. Is that something that we could see on a monthly basis with our minutes? Not part of the minutes, but just with the information packets you put out?
Sure. They aren't, I will say that they aren't typically monthly bills. They're more typically quarterly, but sure, when we get a bill, we'll toss it in there for you. I will say it's unusual, but it's not unreasonable.
I think it would just be interesting for us to all have a.
That's fine.
I don't know, maybe not. Maybe it's just me. I would love to see that.
I think
You find things interesting. I find things interesting. It's fine. It's easy enough to include when we get them.
Do you guys want me to do a monthly instead of quarterly? I've just always done my government stuff quarterly.
I don't know that it holds any difference with me other than the fact just, when it comes around, if I don't see something in 6 months, maybe I'll ask. But yeah, if you're doing it quarterly, I don't want to get involved in how you do it. I just like to see it.
Okay.
Yeah.
I don't have a problem with it if you don't.
No, Thor's completely right. It's public information.
Mm-hmm.
I have no problem putting it up on YouTube with this screen. The last lines there are just the totals that we've spent on legal counsel, which is our professional services budget in the department. But professional services isn't entirely legal counsel, it's just the bulk of it. So in 2017, 2018, and those were with previous legal counsel. 2019, I believe, is when you took over.
Yeah, it was either me or Sam. I think Sam did it for a while.
Okay, that's right. So since 2019, her firm, the same firm, has been involved. 2020, 2021, we had various cases. We had the comp plan coming in. We had a lot of additional meetings. I believe that's a lot of meeting time. 2023, the $1,500 of outside legal counsel, that was that was the case where we had no legal counsel locally that felt that they could serve. So we actually had to reach out to Carson as outside legal counsel for the case. It was a case that wound up getting withdrawn So they didn't actually attend the meeting. That $1,500 was for their meeting prep time, basically. So that was not quite a quarter of the entire expenditure for that year was for that outside legal counsel. You'll notice in 2022, $56 was outside legal counsel. That was where we had a BZA case. I believe it was the only case on that night that Liz had to recuse herself, and we had to go to a different local law firm, and that's what their bill was. So just to give you some perspective there of costs. And that year-to-date amount is inclusive of the bill up above. So that's what we've spent inclusive through the month of August. I think that covers all the different questions about legal counsel. Kind of touched on some conflicts of interest statements as well, more professionally for myself and so on. So it's not just legal counsel, but any other questions, thoughts, any other things I didn't touch on that you would like to talk about?
You didn't touch on the alternates very much, because we've had instances where, you know, our normal legal counsel isn't here and then somebody's sitting out there or over there. We have no idea who that person is or how they, you know, why they're here. So would you touch on that a little bit?
Okay, so like Nathan Lundy. So Nathan is another attorney in the same law firm. So if Liz has an absence, not a conflict of interest, but
Like a time conflict.
yeah, kids swim meet or something like that, then he would typically sit in. He'll sit out in the audience for his own education, so he knows what's going on. But if he's just here, that's why. We try and let you know, but honestly, we don't always know until the absolute last minute. So when that happens, it's not necessarily because of a conflict of interest. If it was a conflict of interest, you wouldn't have the same law firm. Well, unless it was one that you personally had.
Right.
Yeah.
But even if it's a personal conflict for me, because I'm a partner, it would trickle down to the associates, because I'm technically considered like a boss of them.
Okay.
There's one of the benefits that Nathan and I talked about with going with a firm is that if I'm not available, I'm on vacation, I'm out of the office, something happens, we have other attorneys in the office that can be backup or be well versed in the area. Nathan's one of those. He's taken an interest in land use. He took some land use classes in law school and has been very interested in that. And so he'll sit in the gallery or in the crowd and watch and kind of try to learn what's going on. And then he's been my backup. We have another new associate, Olivia, who's going to start at least attending the meetings to get a feel for it. That way, no matter what happens, if one of us is out, there's always somebody that a plan commission member or Nathan can reach out to and get an answer that day. If I'm in an all-day trial in another county, it's really important that Nathan or you guys have someone you can talk to that day if they can answer a question. And so that's what we try to have, that kind of backup and availability for you guys.
So that's good information. So we've essentially hired a law firm instead of an individual, and that's why you can kind of plug in different people and move forward.
And Nathan had come to some meetings with Nathan and I just to meet Nathan and Brent and to get an idea of how the office works. I'll probably do the same thing with Olivia. Just again, that way there's always someone available for you guys, and especially for staff if something happens.
Yeah. So when they're learning, they're being paid by the firm and not the county at that time?
Yeah, so like when Nathan was coming to meetings and just watching, he's not billing. When he was at the meetings and acting as legal counsel, then he was billing for that.
Makes sense.
It's just like I have another associate in the office. Because I do a lot of family law, so she's trying to learn that, and so she'll come into my meetings with me just to kind of see how the process works. We're not both billing the client. She's sitting there observing, and helping out with things as we work through the process. But we're not both billing for that meeting.
Are any of the associates billed at different rates depending on their expertise or tenure?
So the $150 an hour is actually considerably below what any of the lowest hourly rates is in our office. So our associates start out at $200 an hour. I'm at $250 an hour. I just have never raised my rates with the county. That's where I've been at since it started. And I think since I started with the health department in 2016, and I was at $150. I've just never raised it. And I've kept it the same here as well. So we all bill at that same rate because it's so far below what we would make them for any other client.
I have another question. It's kind of a couple pronged here, so I'll try to explain it the best I can. So during the course of an active live meeting, obviously outside of outside of a live meeting, any information that we would get from you would be researched and vetted and brought back into the meeting, and we would be very, it would be very clear that we would have a certain amount of assurance the right answer or the right things are being provided. But during the course of a live meeting, and we sat here and we're stumped on something, or we don't know, and we ask you, and you give us an answer that ultimately, let's say, would be the wrong answer.
That's why it's malpractice insurance.
Who's liable for that? Are we absolved of any of the liability for any kind of repercussion on something that would come from you as far as bad advice?
It depends on what it is. No, ultimately a client is not absolved if their attorney gives them bad advice. That would just be a really good reason not to hire that attorney.
Well, we don't want to find that out too late. That's for sure.
That's just,
Yeah.
Yeah, I'll kind of chime in too, because you're a board. Oftentimes, not oftentimes, but in the time or two that I can think of where an attorney did basically give their board faulty advice. I don't know, bad may not be the right word. And it did go to the courts then. The court basically said what you were told really just wasn't sensible. And so they just remand it back to get it reheard and say, fix this advice, that was wrong. So it's not quite as drastic as sometimes as it could be in those instances.
But that could come to, that could come to a lot of different levels too. You're
Very much so.
painting a picture that would be something that we would all pray for or hope for if we ever did do something wrong. But I think that's probably the least most.
It would also depend. So the challenges are going to come if it's something that's obviously wrong. Like let's say notices don't go out correctly, and I tell you what, it was appropriate notice, but it's obviously wrong under the rules. That's going to come back to redo the notices. Where the challenges come from are the gray areas. Those are the cases that are going to go to court because it's not absolute one way or the other. Sometimes they are, but it tends to be gray areas that get challenged and go to court. But yeah, typically those are things too that I'm looking at in the staff reports. And then that's why I call Nathan the day of to say, hey, are there any issues? Because I'd rather tell Nathan, hey, be aware of this issue. Maybe beef up your staff report and put this in it because I'm concerned about a challenge on this issue. Instead of saying it to a room full of people that are watching with news cameras out here, right? I'd rather, and then if you guys have a question, obviously we can talk about it. My goal is to have the staff reports and the proposed findings. That I work that out with staff as much as possible beforehand to avoid in a public meeting discussing potential legal weaknesses to an argument.
And another thought too, I've told you before, my staff reports are my opinion, opinion is the right word. It's my opinion to you guys. You don't have to follow really anything that I give you as advice. So you can still strike out on your own. Same thing with legal counsel. You don't have to follow legal counsel advice.
I have
But the
lots of
difference,
clients that don't.
but the difference being is you're not a lawyer though.
Right.
No, but he has a specialty in planning.
Yeah.
So he has an expertise in an area that does have some legal knowledge, but also an expertise in planning, and he's giving you that expertise in his staff reports.
But it's held to a different standard.
Yeah.
Than what a lawyer is.
Yeah, I have my own set of standards. Yes. So yeah, that's still, if you just don't feel like the advice that we're giving as professionals is what you want to follow, you still have the option to go out on your own. And then we, again, if it's your decision, it's our obligation to back you up and say, they opted this way, we still defend you. Well, you'll defend, I'll support.
Well, I know I'm just going to say I've been on here for 8 years. I know you've been on here for a lot longer, and everybody to a certain degree. But outside of a staff report and some of the stuff that's very similar, I don't have the in-depth knowledge to know if you're giving me a bad staff report or not. I mean, I really don't. I don't know how anybody else feels, but I don't know how we would really know if we're getting a bad staff report.
You would know because you get a lot of legal challenges.
Well, right, after the fact.
That's how you would. Yeah, but that's how you're gonna know.
Well, right, but it's after the fact.
Yeah.
That's why that kind of goes back to the start of the question as I presented it. It's after the fact doesn't do us any good.
Yeah.
So we just need to make sure that we're probably educating ourselves more so we can recognize a bad report.
Yeah.
A bad staff recommendation. And I'm not saying that you give any or that you ever would, but
And a large part of your reports are opinion. I mean, would you agree with that?
It's the way I tailor my reports, it's basically laying out what the facts of the case are, how the code applies, and then the interpretation of that. So the interpretation is the opinion part of it. My interpretation is based upon both law, past practice, past precedent of decisions made here, as well as larger. So it's not just me saying, I like this. So if you say it's just my opinion, no, that's not the case. But it is an opinion, but it's based on multiple factors.
And that's sometimes the advice I give too. Like, I can tell you what I think is likely. I can't tell you 100% what an outcome would be if a case got challenged. I can say based on the case law that I see now, based on my reading, this is what I think is likely to happen. But I mean, there have been cases, not many, but sometimes when they go up on an appeal where you're like, everything beforehand said X was going to happen, and then they're like, well, now we're just going to change our mind, and Y is what we want to see happen in these types of cases.
Yeah.
There's never a guarantee of outcome. So much so that in all of my contracts that I have with private clients, there is a disclaimer that says I can never guarantee you outcome in a particular case.
Yeah. Even with land use is a little bit calmer than, say, criminal cases or other
law,
family law. Yes, thank you. But even then, even the Supreme Court has had some surprises over the years, just basically overturning their previous precedent. Because times change, the courts change, and so on. So
what we're dealing with is a lot slower moving.
It is.
Than the dynamic of family law.
Very much so.
Mm-hmm. Like there was, in the time that I've been either on the, because I served, some of you know I served on the Planning Commission before being counsel. Duke would be the biggest case that came out in that time. Mm-hmm. Duke Energy. There was a recent Indiana Supreme Court case about a Duke Energy substation or office building in Hamilton County that Nathan and I talked about quite a bit because of the ramifications it could have for different things. That's in that time. That's probably the biggest Supreme Court case, the only Supreme Court case I can think of about planning or zoning.
Well, that would be Indiana Supreme Court. Yeah.
Indiana Supreme Court. So it just doesn't happen very often, and a lot of that is because if you have businesses, well, one, for individuals, it's really hard to get that far because it's expensive. For businesses, they're risk averse, and so they want to try and reach agreements outside of appeals. And to the extent they can do that to avoid risk and attorney's fees, they're gonna try to cut a deal somehow.
At the national level, the U.S. Supreme Court, they deal with land use cases probably every year, but the landmark cases that really make a big impact, I'd say about every 5 years there's something that comes through. So as opposed to every year you hear something that the U.S. Supreme Court's done that is dealing with other things. So again, about every 5 years for a landmark land use case. Most recent was dealing with signs. Signs are kind of a perennial thing at the national level.
But I check about once a week, once every 2 weeks. I go through the Indiana Supreme Court opinions and Court of Appeals opinions, not just for you guys, but for any appellate case. If there's something new that I think would help me just represent my clients better, looking for Plan Commission and BZA cases is another one that I do too. And if it's something notable, I'll let Nathan know about it and what I think.
And vice versa. If it's something that is planning related, I let her know, I let you guys know, hey, heads up, this is something that's coming through. Either directly, if it's something really immediate, or through training workshops.
So, last question, I promise.
It's okay.
If we do something really stupid up here, what's the likelihood that the liability for whatever stupid thing that we do stops at the county level, or can it follow us into our personal lives?
What do you mean by liability?
Well, I mean, if we do something and we get sued and there's a judgment that's ordered, does that stop kind of at the county government level, or can that chase us into our personal bank accounts?
Because they don't have any financial control over anything as Plan Commission members.
Mm-hmm.
So, I mean, other than losing, right? Like being told you guys decided this wrong when you voted. I can't think of anything that would be personal liability.
The personal liability would be if it's proven that you personally, you had an undisclosed conflict of interest. You actually did something under the table, and that would be a personal liability. But
it would have to be something that's almost criminal.
Yeah.
When like something official misconduct.
Yeah. Thank
something
you.
like that. Okay. But as far as like you voted the wrong way on a case, right? Like you get those judicial reviews, like a rezoning. Goes to the commissioners, they vote, and then the commissioner's decision, your decision gets appealed. You're gonna win or lose that on a judicial review, meaning your decision either stands or it doesn't. It's actually the commissioner's decision, but you would get sued too. It's not like now you guys owe this person $50,000. It's either that legislation stands or it doesn't. Does that make sense?
No, it makes perfect sense, because if you think of it that way, we are just a subcommittee of the commissioners.
Right.
And we're not really making any decisions. We're just doing background work and making that first decision, but it goes to them and they can completely ignore any decision that we make.
Right.
So that does make a lot more sense.
And usually government officials are sued in their official capacity because there's rules like sovereign immunity, or you've probably heard about qualified immunity when you were an officer. There's rules, very distinct rules about when government officials can face liabilities for their actions, and the government also almost has to allow it first before it can happen. So think of like a tort, like a car accident or hitting somebody. But anything you do in your official capacity as a government official is kind of protected from personal liability.
From my perspective, it's kind of an assumption that you are appointed officials, you're acting in the public's interest, and therefore if that decision, whatever decision you make, is in the public's interest, if it winds up going to the court, then again, it was in the public's interest by way of you people, you members as a collective whole, if that makes sense. And so there is no individual in that decision at that point.
But if every legislative official faced personal liability because of a vote someone didn't like, the courts would not hear any other cases.
So I have a question. We spend a lot of time talking about conflicts of interest, and we recuse ourselves or somebody does regularly. Going back to the code development committee that we had several years ago, the county brought in a mediator that was literally working for one side, one group. And that brought a lot of negative attention to that whole situation. How was that even allowed to happen? I mean, to me, that's just absurd.
That would be a good question for that attorney, because that was not a disclosed fact, and I have never been shown that that attorney was getting paid by anybody at all, by an opposite side, by either side. Let's just say that. So if that was happening, it was never disclosed. So,
but the way I read that should have never happened.
If that was so, like,
yeah,
here's
point blank. I mean,
well,
yeah,
in
and
black and white.
Point blank, it should have been disclosed.
It should have never happened.
Yeah,
But that's on the attorney to tell you that, correct?
correct. And that was not disclosed.
But I don't. So to make clear what the actual conflict rules are, it's just because somebody's a current client. Although I tend to get out either way, but technically under the conflict rules, it has to be a related matter. So if I had a client on a personal injury case, right, because they're writing, like, they get hit in a car accident, and then they come here for a petition to rezone real estate that's not a part of the personal injury, has nothing to do with it, that wouldn't technically be a conflict under the rules. It might put me in a bad spot, because if it's contentious, my client might get mad at me, but it's not inherently a conflict. There are times when we choose to get out just because we feel like it's a bad place to be in between two clients. But it has to be, the matters have to be adverse to each other.
And I think in that instance it was.
It sounds like it was, if they're getting paid directly for services from one of the
Well, it would have to
parties.
be related to what they were doing
Yeah,
to be a
well,
conflict.
that's kind of what it sounds like, was they were getting paid for the services that were providing the county, which
I don't think they were.
is news to me. So
Yeah, if he wasn't getting paid by one party to do mediation, that would be a conflict.
So yeah, this is the first time that I'm hearing this level of detail about that accusation. So
The cases where I've had a conflict recently have been cases where it's not just that they're a client of the office, but there's something kind of ancillary to or related to what the petition is that someone in my office is helping with. So, like, let's say this isn't an exact example, but it's close enough to give you an idea. So, like, let's say there's a parcel up for rezoning, and that rezone is a contingency for a land sale, and my partner's helping with that land sale, helping close it. I would get out of that case because even though he's not representing them on the petition, it's related to that land sale that he is representing the client on. So I would view that as a conflict, and I would tell him to get somebody else. But other than that, we don't take clients for land use issues in the county. We refer them out because we represent the county. Plan commission.
So you, as a law firm, don't do any work in the land use field?
No, I said it in Whitley County.
Whitley County jurisdiction.
Whitley County jurisdiction. So we've done city. In fact, Nathan had one not that long ago.
Mm-hmm.
We've done Noble County. We've done Kosciuszko. We don't do any in Whitley County because that would be a direct conflict. It's kind of like Bob Ehrman represents Allen County Plan Commission. He doesn't take any Allen County cases in their jurisdiction. He does a lot of land use outside of Allen County.
Well, we have kind of gone all over the place. Any other questions for us? I enjoy this.
No, that satisfied me, thank you.
Yeah, thank you for putting that together, and I think to summarize, maybe just add a financial statement with our information whenever you have those available.
Yeah.
Hopefully we all learned a little bit.
Easy enough to tack on. And then just, if you don't mind, just a reminder that we do have a training session scheduled for the 29th, Monday the 29th. As we found out last year and as we talked about, this is going to be more of a roundtable of our communities. So rather than a specific, you're learning about X, it's going to be more of a talk amongst yourselves, have some topics to talk about, but still, hey, how are things going in Busco versus South Whitley? And that seemed to be a very valuable thing that we did last year. And so this is the same thing again this year. So again, more of a roundtable setup than a lecture, basically.
It might be a tough night because I have on my calendar that's the opening day of the season for the curd burger at Culver's. And they only have it for 14 days.
The curd burger?
The curd burger.
Maybe we
Never
could
had a
have,
curd burger, you need to check it out.
Do we need to have a change of venue? Is that what you're suggesting?
we could either have it at,
Okay.
Oh, okay.
So
So we're not adjourned yet, but anyways, Monday the 29th.
Monday the
This room?
29th should be at this room unless, again, we'll announce if it does change the venue to Culver's. But otherwise here, I believe 6 o'clock. But we'll give you the details probably coming up next week.
Anything else from staff or members? Alrighty, the meeting is adjourned.